For the record, this matter is before the court for review. Subject to the parties having engaged in mediation with Ms. Patrick this morning. This hearing is being conducted via Zoom. President Attorney Amber Billmeyer representing the plaintiff father, David Show, and Mr. Show is present with Mr. Billmeyer. In addition, Attorney Christine Hills is present representing the defendant mother, Amanda Branshaw. Ms. Branshaw is present, and in addition, Guardian ad litem Stephen Jednick is present. Good morning, everyone. Good morning, Ms. Patrick.
Morning, Your Honor. Good morning.
Good morning.
Morning, Your Honor.
The court has reviewed the report of Guardian ad litem. Thank you, Mr. Jednick, for your involvement and assistance in this file. Have the parties been able to reach an agreement with the assistance of Ms. Patrick this morning?
Yes, Your Honor.
Yes, Your Honor.
Wonderful. Who would like to place that on the record?
I'll have Ms. Billmeyer do that.
Sure, it's very simple. Your Honor, the parties have agreed to move the mediation to April 18th at 9 a.m. and parenting time is reserved between father, the plaintiff, and Cole. The remaining orders remain in effect for the child to go to counseling. That is the summary of the agreement, Your Honor.
That is correct.
That's April 18th at 9 a.m. Is that correct?
Yes.
Okay. Do counsel what they want? Do you want to review by this court after that mediation? Do you want it on the court's docket?
I think that would be a good idea.
I have no objection to that.
That's fine with me.
Very well. Anything else for the record this morning?
No, Your Honor.
Yeah.
Much easier than yesterday.
All right. Well, obviously, the court's learned something about this case from the Guardian ad litem report, and obviously, Ms. Branshaw, you need to step up and do something to repair this relationship between your son and Mr. Show. The court is just flabbergasted that you would tell, if this is true, a 3-year-old that the individual who he knew as a father all these years was not his biological father. And obviously that would create a lot of animosity and anxiety on a young child. So if that's true, shame on you. That's all I can say. You need to, if you care about your son, you need to restore that and repair that relationship, Ms. Branshaw.
Yes, sir.
She's doing everything she can, Your Honor. She's making sure the child gets to all of the appointments, coordinating and informing Mr. Show of psychiatric involvement at the request of the therapist. She has gotten Cole to all of the family counseling and shelter services visits, whether Cole proceeded to go into the office or not. She really is working very hard to assist. She knows the importance of the relationship between Cole and Dad.
It's just, of course, it's very disappointed. It's just to see a young child go through this and caused by his own mother, in large part. Any event. That being said, all right, the court will mail out notice. Do you want an order entered to this effect that the parties appear for mediation, community mediation with Ms. Patrick April 18th at 9 a.m. If so, Ms. Patrick, can you prepare something to assist the attorneys?
Your Honor, I can, but we've already put it on my calendar and I believe everybody's aware of that date.
All right. There'll be nothing in the court file then, but I'll put it in my calendar. Maybe nothing in the court file about this without an order. So I'll put in my calendar April 18th, but obviously there's no order. So if the parties choose to change that, nothing the court can do. All right.
Judge, I'll prepare an order that indicates that the parenting time with Cole is reserved and that stays the same with Brantley and continuing in therapy and those sorts of things. I'll prepare an order.
And just so the court's aware, Your Honor, there's an open motion to modify custody and parenting time. That motion is being adjourned. That motion is still open.
Yep, the court notes that the court reviewed that yesterday.
Thank you.
So Ms. Hills, could you put in your order that the parties will mediate with Ms. Patrick April 18th at 9 a.m. and subsequently appear before the court for review?
Yes, Your Honor.
All right, wonderful. Anything further, Ms. Billmeyer, Ms.
No,
Hills, and Mr. Jednick?
No.
All right, thank you, Ms. Patrick. That will conclude this matter. You can all zoom out.
Thank you, Your Honor.
For the record, this matter is before the court for continued pretrial conference subsequent to sorry, there was no mediation scheduled this morning, but this pretrial conference is being conducted via Zoom. President is Attorney Alexis Spencer, representing the plaintiff, Amber Rojo. Ms. Rojo is present. Good morning, Ms. Spencer.
Good morning, Your Honor.
Mr. Rojo did not appear this morning. Has Ms. Rojo attempted to text him?
No,
Reach
there's
out
a
to
no
him?
contact order in place.
I'm sorry?
There's currently a no contact order in place between the parties.
Is there a domestic violence charge pending?
I'm not sure if there's a domestic charge pending, but I do know that she called the police when the incident occurred. There's been multiple events.
Okay, he just appeared, but obviously, Ms. Spencer, you could reach out to him. Obviously, it's much easier if we get his involvement as opposed to jumping through all the hoops, but I'm informed that he's now appearing.
Okay, yeah, and I did try to reach out to him, but the cell phone number I had was no longer working.
Okay, well, we'll talk to him and verify his current address. How long have the parties been? Mr. Rojo, can you hear the court?
Now he does.
Can you hear the court, Mr. Rojo?
Yes, I can.
All right, Mr. Rojo, we were just about ready to conclude this matter because you're a little bit late this morning. The matter was set for 10:30. It's now 10:40. Mr. Rojo, can you please provide the court to verify your current mailing address? Port, P-O-R-T.
CT.
Court.
Oh, court. I'm sorry, court. C-O-U-R-T.
Yep.
Okay, the purpose of this pretrial conference, Mr. Rojo, is to move the matter forward. We have 9-year marriage. How long have you been separated? Approximately a month.
Yeah, a couple months.
Okay. Ms. Spencer, Ms. Rojo, what, I'm just looking for a month.
Yeah,
June,
Your Honor.
September.
It has been since, let's see. It's been quite some time.
Ms. Rojo?
Since July.
All right, that's good enough. I just looking for some idea. So about good 6 months. Very
Yes,
well. I'm
that's
gonna have you
correct.
talk with, I'm gonna have Mr. Roman have a talk with Ms. LaPrade in front of the court. She's going to see what's if she can facilitate some resolution this morning. There are no children. I don't know what the issues are, but I'm going to talk with Ms. LaPrade from the front of the court. And after you do so, if you don't have an agreement, then the court will address the matter. Okay.
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 All right.
Thank you.
Plaintiff, the court, the parties have conferred briefly with I believe, Mr. Pratt from the front of the court. The court has been informed that the parties have reached an agreement relative to all outstanding issues. Is that correct, Ms. Spencer?
Yes, that is correct. Thank you.
Wonderful. Mr. Rojo, is that correct?
Yes, that's correct.
All right. So, Mr. Rojo, listen carefully. Ms. Spencer will state what she understands to be your agreement. And after she does so, I'm going to turn to you and ask you whether or not it's an accurate statement of your agreement of all outstanding issues. Understood?
Yes.
All right. Ms. Spencer, could you please state what you understand to be the party's agreement?
Yes. So the agreement is as to the property, Mr. Rojo will be awarded the counter and table in the basement and his personal items such as clothes, shoes, jewelry, things like that. He will come to get that property from Ms. Rojo's residence, and he will do so on Sunday, January 28th at 10 a.m. Ms. Rojo will not be present at the house. Her mother or another person will be present while Mr. Rojo is there getting his belongings. He will also take half of the tools that are in the garage that Ms. Rojo will go through before that date and separate 50-50. And he will also take the smoker and the grill that are currently in the garage. He also will take the 79 Pontiac Trans Am that will actually need towed from the home. That hopefully will also happen on Sunday, January 28th. But if not, I have Mr. Rojo's number and be in contact to set a date and time to have that done as well. There are no debts that need to be divided between the parties. They will just each keep the debts in their own name. Mr. Rojo is leasing a 2015 Silverado that he will keep in his own name, and Ms. Rojo is currently just driving her mom's vehicle, so she doesn't have a vehicle that needs to be dealt with. Spousal support will be forever barred as to both parties. And for the 2023 taxes, each of them will file separate. And I believe that is everything.
Okay, there's no real property, is that correct?
That is correct.
Pension benefits, will they each keep their own?
Neither of them have any pensions, 401ks, anything like that.
Thank you. And again, there are no joint debts, correct?
That is correct.
All right. Thank you, Ms. Spencer. Mr. Rojo, did Ms. Spencer accurately state your settlement agreement?
Yes,
And do you understand if the court adopts this agreement, there will be no trial or hearing of any type of nature?
yes.
Okay. Ms. Spencer, do you have any questions on Mr. Rojo?
I do not. Thank you.
And the last question, Ms. Spencer, you'll prepare the judgment of divorce. How will you present that to Mr. Rojo? Are you going to submit that to him under the 7-day rule or for his approval?
Yes, we actually discussed that with a friend of the court, and he stated he would prefer that I 7-day it rather than him coming into my office to sign.
All right. Thank you. So, Mr. Rojo, Ms. Spencer is going to prepare a judgment of divorce. You can reduce this agreement to writing. She's going to mail a copy of that to you along with the notice saying, unless you file a written objection within 7 days, this judgment will be submitted to the court for signature and entry. And of course, once the court signs it, you'll be mailed a true copy of that for your records. So if in fact there's something in the judgment, maybe it's a typo, if you have a problem with it, call Ms. Spencer first before you file the written objection. If everything looks fine, you don't need to take any action.
Okay.
Okay? Well, I would like to thank you, Mr. Pratt, as well as Ms. Spencer, for helping facilitate ample resolution of this matter. Based upon the testimony that's been presented this morning, as well as claim following this matter, the court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, upon receipt of the written judgment, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved, and judgment shall enter granting a divorce from bonds of matrimony. Good luck to both of you. Thank you again, Ms. Spencer, for your fine assistance. We'll now conclude this matter, so we can zoom out and have the rest of the day.
He didn't come because he thought it was dismissed.
Well, it's
And we
not.
got him, and he doesn't have his client here. So we told him.
Let's call the case.
Court is now in session. Guy Bickley versus Renee Bickley.
For the record, this matter is before the court for a pretrial conference. The same is being conducted via Zoom. Present is Attorney Ron Bruce, representing the plaintiff Guy Bickley. Who is currently not present, and ma'am, you are Renee Bickley.
Yes, I am.
All right, Mr. Bruce, can you get a hold of your client?
I did try calling him, Judge, a minute ago. He didn't answer his phone, so I wasn't able to bring him in.
Ms. Bickley, do you have any way of reaching your husband?
I do not. I have a PPO against him, so I don't. Yeah, and I really don't have any way of reaching him.
Okay. Ma'am, could you please state your name and current address for the record? Okay, Ms. Bickley has filed with the court. It says confidential, but it's in the court file. I'm not sure, Ms. Bickley, how it got in the court file. Did you want this to be a confidential address?
You know what? It's okay. It doesn't matter. But I turned the address in so they could send me information.
Sure.
But they did say it was going to be confidential. Yes.
Mr. Bruce, did you capture the address?
I didn't. If I could get that, I'd happily send her.
65. Ms. Bickley did complete a change of address form and filed it with the clerk of the court on January 4th, 2024. Ms. Bickley, you have not yet received a copy of the complaint for divorce. Is that correct?
Yes, I did receive it. Yes.
Oh, who's they?
No, I've got two things going on here. We have a domestic violence case actually too. So I'm just thinking what I got, but I did get a copy of that.
Of what? The complaint for divorce?
Yes.
All right. Okay, I'm not sure who got it from, but in any event, the two have been married for 8 years. They've been separated since September of 2023. Is that correct?
Yes.
All right. Mr. Bruce, did you leave a message for Mr. Bickley to call you back?
His phone didn't accept messages, but.
Oh, okay. What about a text message? Well, I don't know how that works. If he doesn't accept the phone message, what about a text message?
I don't think he texts, honestly. I think he showed me his phone, and I don't think it had text ability.
All right. He should have been here, Mr. Bruce. Obviously, I understand the summons expired, but again, yeah, if in fact you didn't think the pretrial was on, you should have called the court. We would have said, no, we always leave these on because 9 times out of 10, parties appear.
I mean, is the defendant officially served at this point then, Judge, or do I need to read it?
The court, if you want the court just to dismiss it, or I can do that if you prefer that. Have Mr. Brickley start over again?
Sounds like the parties probably need to be divorced. I know my client told me to refile it. Obviously, we thought she was on Newport Road, then obviously we'll like to proceed.
Okay, this is a deal. We need to do this quickly, and but you have no other means to reach your client other than the letter. Is that correct? You have any third parties, Miss Bickley? Do you know who your husband lives with? Does he live with a mother or
No,
sibling?
he is the one that's on the road. That's his house. That's where he lives. And I mean, I'm not, what do you call it? Fighting anything. Can we just finish it today?
We need him here, and he's not responding to a phone call. So I'm trying to find out, how do we reach Mr. Bickley by phone? Does he live with a mother or sibling that you can reach out to?
No,
Would the court consider scheduling a mediation with Miss Bickley? I'll make sure my client's there, and I suspect it sounds like we would just be resolved on that day.
All right, we can do that. The court will complete a pretrial statement. We'll note that Mr. Bickley's not here, and hopefully he can be there. What are the issues, Mr. Bruce, as far as you know? Is obviously spousal support is not an issue. Is there a real property that needs to be divided?
I think my client has property he owned prior to the marriage.
Miss Bickley, do the two of you own real estate together, or there's just real estate owned by Mr. Bickley?
I'm not asking for anything. No, we don't have anything that we own together.
The court's going to complete a pretrial statement. I'd like to get some idea of what's at issue. You're saying nothing's at issue. There's no joint debts, no real estate. You don't want anything?
No, there's nothing. We just want it over.
Okay. Are there any joint debts that need to be divided?
No.
Okay. Well, I mean, what's the purpose of mediation then? You don't want to meet with the mediator? You basically just want to get divorced, and you're going to give everything to Mr. Bickley?
Yes, I just want the marriage ended.
Of course, you should talk to an attorney. For example, you may have an interest in the appreciated value of that real estate. You may have an interest in his retirement.
I don't. I've already checked with a lawyer regarding that, and I don't have the time in.
All right.
Claim any of that.
Has personal property been divided?
Yes, I have I have the things that are mine, and he has his.
Okay, so there's nothing at issue.
No.
Well, I mean, we will. Mr. Bruce needs time to mail something out. Miss Cindy, what do you suggest? Are we available on February 1st for another pretrial?
Yes, we're February 1st, 2:30.
That's fine.
That work with your schedule, Mr. Bruce?
Yes.
All right, Miss Bickley, are you available? February 1st is a Thursday. It's actually 2 weeks from today at 2:30. Would you be available to zoom in once again?
Yes. Will there be a finalization on that day?
Yeah. Well, if you have an agreement, it'll be stated on the record. Mr. Bruce will say in the record that Mr. Bickley's awarded what's his, and there's nothing at issue. The court takes a brief testimony that there are no minor children, not now pregnant. And yes, we can finalize everything, but Mr. Bruce needs to prepare a judgment. Mr. Bruce, if in fact that's the case, he can prepare a judgment in advance, and you'll submit that to the court, and then the court will send that to Miss Bickley. If Miss Bickley approves it, the court can sign the judgment that day. Miss Bickley, do you want your former name restored?
I do, Ash.
Okay, now do you want to you need to approve this judgment. If you want to sign it February 1st, you need to see it and approve it in advance.
If she wants to give me her email address.
I give my email address. Can I just sign electronically or?
Yes.
Okay, it's Renee.
Yeah, I'll send you a judgment ahead of time. You can just sign it electronically, and we should be all set.
All right, thank you.
All right, so the court mail out notice, we'll have everyone back February 1st at 2:30.
Okay.
Thank you.
All right, thank you, Miss Bickley, for appearing today. All right, Mr. Bruce, that'll
Thank
work.
you.
You're welcome.
Thank you.
We'll send out a notice for June pretrial this morning. Miss Banks did appear. However, she has returned personally to complete proposed judgment divorce. The court has reviewed with her what's necessary in order to enter a default judgment. And the court will schedule this matter for entry of a default judgment and continue pretrial on February 1st at 9 a.m. via Zoom. But the court wanted, since she's personally present, the court neglected to take proofs this morning. So, Ms. Banks, can you raise your right hand to be sworn? Thank you. Ms. Banks, is it true that you filed a complaint for divorce for this court on about August 2nd, 2023?
Yes.
Is it further true that on the date you filed the complaint, you had lived in the County of Monroe, State of Michigan for at least 6 months?
Yes.
Is it further true that you married to Brandon Scott Banks on March 9th, 2023?
Yes.
And you've been separated for a period of time?
Yes.
Is it true there's been a breakdown of your marriage relationship to the extent that the objects of matrimony have been destroyed and there's no reasonable chance of reconciliation?
Yes.
Were there any children born during your marriage who are still minors?
No.
Are you currently pregnant?
No.
Do you have any questions for the court? Right, appreciate you coming back. Based upon the testimony that's been presented this morning, as well as complaint files, the court finds that jurisdiction has been established. The court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, upon receipt of a consent judgment or the failure of Mr. Banks to appear for the continued pretrial conference on February 1st, 2024, the court will enter at that time the proposed judgment of divorce by default. And at that time, the court will order that the marriage between the parties be dissolved and the judgment will never grant any divorce from bonds of matrimony. All right, Ms. Banks, you're all set. Thanks for coming for stuff back in here. You're set to go. We'll give Bailey a copy of all this. We'll see you then via Zoom on February 1st, 9 a.m. Hopefully get your divorce at that time.
All right, thank you.
And then when you get a copy of this, once you get the copy of signed judgment, you need to copy it to Secretary of State and Social Security to facilitate the legal change of your last name.
Okay, thank you.
You're welcome.